Michael Cooper of Cooper IP. And Michael is an Australian and New Zealand registered patent attorney. And he's also an Australian registered trademarks attorney. And he works across Melbourne and Tasmania. And pre-COVID, was in Tasmania quite regularly. Michael has been a wonderful friend of the TCCI and TradeStart, and Michael has been a speaker at IP seminars I've held here at the TCCI previously. So it's absolutely wonderful to have Michael back again to speak with us about managing and protecting your intellectual property. That is becoming more important than ever. So welcome, Michael, and over to you.
Great. Thanks for that, Sally. Now, just thanks for organising and thanks for hosting this event to you and the TCCI. If you would just bear with me for a moment while I share my screen. I think that should all be fine. So thanks for hosting. I'm grateful for everyone that's taken some time out of their day today to listen to this. It is a really important topic. It's one that we feel strongly about, obviously, and unfortunately it flies under the radar for a lot of people. So we really like to get out in public and talk to people and try and raise some awareness and get people thinking about IP, because it can be a fantastic tool, or it can really cause some grief, particularly when you're heading into international markets. I'm just going to go to the next slide. Bit of a delay there, but there we go. Look, we've just got a disclaimer in here. We'll make these slides available to anyone that wants them. IP is quite a complicated field, and it always depends on some really specific circumstances. So what we're talking about today is really general in nature, and if you have any specific questions, we offer a free initial consultation, and we're really generous with our time, so please pick up the phone and ask us before making too many assumptions, because we really want to help out. So who are we? Cooper IP, two main attorneys, myself and Warren Wong. We're both engineers, mechanical engineering background, patent and trademark attorneys. With legal training as well. I worked in industry for a few years before becoming a patent attorney. Worked for Holden in the automotive industry, which is no more. Before COVID, we spent quite a bit of time in Tassie. We were down at least 2 days a month, one day in the south, one day in the north. As cold as it looks on the weather down in Tassie at the moment, I'd certainly rather be there than be in Melbourne. As you know, we're in an increasing stage of lockdown, so it's not much fun being in Melbourne. We're making the most of it. Now we work with a lot of Tasmanian businesses on the mainland as well. We work for everyone from sole entrepreneurs, mums, dads, farmers, to SMEs, people that are making and doing things. In past lives, I've worked for multi-billion-dollar corporations that the likes of Microsoft and Nike and Busy and Kmart and the like. So I've really worked across many different industries and seen many different ways that IP can be used, and also IP can trip people up. Our approach at Cooper IP is to really try and simplify it and offer pragmatic and commercially focused advice, because there's a lot of things that we need to know, but you don't necessarily need to know them, and you just need to know what decisions you should be making and when, and how to get the most out of it for your business. So today we're talking about the importance of IP registration for international markets. As we both mentioned, it's a really important topic. The way I'm going to attack this is just a little bit of an outline of what IP is. We do lots of IP 101 type seminars, and today's not such a seminar. We really want to get into the practical tools and the advantages and the issues and how we use this in practice and what to look out for. So if you want some more general information, we've got quite a bit on our website, as well as some past webinars that we've recorded. So please, by all means, browse that material at your leisure and do some research, or just reach out if you've got any general questions on IP that you'd like to talk about. I'm going to talk about IP as a business tool, then move on to the advantages of international protection and some of the common issues that that people don't realise until too late. So getting onto it, there's some abstract definitions of intellectual property, and you know, most people don't understand what it is. But as the name suggests, it's property of the intellect. It's what we create. I often like to think about it, ideas, and that light bulb moment where you come up with a solution to something, which might be a new product or a great name or a great brand or something like that. It's that moment where things just light up, and it's that eureka time for people. Us humans, we're a creative bunch. We spend a lot of time and resources coming up with new things, and you know, they might be works of art, technologies, companies, business ideas. Pretty quickly we realise that if people are going to put in the hard work and take risks to develop these new industries and new products and launch their endeavours, then it's pretty unfair if people come along and just copy them after they launch. So over time, intellectual property protection systems have developed, and the purpose of that is to encourage people to take risks and to develop technology in society, and at the same time give them something in return for their efforts, and also give them some control over how their inventions are being used. So when it comes to intellectual property, we've got some main types, and these are the business tools that most people have probably heard about: patents, designs, and trademarks. Patents are functional; they protect the way things work. It's a conceptual form of protection that doesn't matter how. If you're protecting a product, for example, it doesn't matter what color it is, how it looks, what material it's made out of. If it works the same, it can still fall within the scope of a patent. Design registrations are visual. They protect the visual features of an article. They're great for things like glasses, drink bottles, consumer products that have been around for a long time but have a new appearance to them. And trademarks protect your branding, stop others from using similar branding. The term branding for me really, it is quite brief, and it doesn't really capture so many things, so many tangible aspects that come into branding. We're often trying to protect those, the goodwill and the way people see your brand and people interact with your brand. I went to a seminar recently, Janine Ellis of Boost Juice, and an amazingly successful company. And she talked about the different things that they do and how they interact with their customers and their suppliers, and all about who they are and what they stand for and how they run, how they operate, and all that's protected in their trademarks and through their branding. And so there's quite a lot that comes into that, and it's particularly relevant in Tasmania, where you've got this great, clean, pristine reputation, and it is really important to protect it properly, and also get the most out of it that you can as a business owner. So some other types of IP, copyright's also quite relevant if you're generating content, artistic works, the like. Confidential information, circuit layouts, plant varieties can be quite relevant to Tasmania. People growing different varieties of produce can be very relevant, but it's often overlooked. It got some recent coverage. There was a New Zealand company that had some kiwi fruit species misappropriated and taken to China, and the New Zealand company was quite successful in getting some really good remedies terms of not just cost, but also ceasing stopping importation of these products. So if you are playing around in that space, then certainly be mindful that you can protect your plant varieties and also enforce them. Trade dress as well can be quite important, as well as trade secrets. Trade secrets are often overlooked, and there are certain steps that need to be put in place if you are hoping to claim protection as a trade secret. Things like making sure that your employees know that they're a trade secret and taking steps that people can't easily access them and things like that. So, as with most IP things, there are the devil is always in the detail. So I've got a simple example here, and it's one that most people will realise what it is. Coca-Cola bottle, and it's a great way to illustrate the different forms of IP protection that are at play here. We've got patent protection around the lid, the manufacturing process. When it comes to lids, there's lots of IP in that space. Mass consumed products like lids, coat hangers, packaging, for example. If you can get a couple of grams out of the product over the large volume that they're made, it can translate to an incredible amount of money. So people are very keen to protect and strongly enforce those rights, because if you're a manufacturer, it really does give you a great competitive advantage. Moving on to bottle shape, design protection is the obvious one, but also trademark protection by way of shape trademarks can also be possible. Then we've got the brand name. Coca-Cola is the obvious base trademark, but there's also the logo, stylized form of Coca-Cola. Coca-Cola actually has many registrations on the register to their different slogans and forms that they use for their branding. So if the business that you're in really revolves around branding, it can be this case where you actually have half a dozen different trademark registrations to protect the way it's actually used in all its different forms. And then also we've got the recipe, which is a trade secret, and Coca-Cola must be one of the most well-known trade secrets. I think it's 130 years old, Coca-Cola. Potentially, when they came up with the recipe, they could have sought patent protection that would have lasted 20 years, and at the end of the 20 years, others would have been free to make it. But it's not the case here. 130 years later, they've managed to keep it secret and still making an incredible amount of money from it. So it's a great example of chalk and cheese as to how different outcomes would have been depending on which route they've taken. So Coca-Cola is a great example, but we all know about it. But I'd also like to show a local example of a company called Scoot Boot, who are based at Cambridge, Tasmania. So these guys are doing really well. They make boots for horseshoes. If not they're one of the leading manufacturers of horse boots in the world. So they're really just going from strength to strength. They have patents around the way the hoof boot works, various functionality about what it is and how it's better than the prior art. We've got some design registrations around the way it looks, because it is a really unique design, and also some protection around the branding as well. So they've got a comprehensive portfolio, and it's really helping them get some traction overseas. And being a leader in their field, people copying them. They're getting copycats from all directions. People trying to, they're seeing that they're taking over the market. They're getting some great penetration, and people are trying to see what they can do. So spending a lot of time with their IP, trying to keep the imitations at bay and maintain their competitive advantage. So IP is a business tool. It really is. Patent. I have lots of clients that are inventors, and they like patent certificates on the wall, and they look great, and it's a great form of recognition for them. But at the end of the day, IP is a business tool, and it really needs to align with your business goals and objectives, and that's the way you get the most out of it, if everything lines up. The direct benefits from having IP is a monopoly, stopping others from doing what you're doing. It's an exclusive right to exclude others from using your intellectual property, which can be incredibly valuable. If you're a widget maker, for example, and you hope to sell your product in the US, a market of 320 or so million people, you only need a really small percentage of that to have an incredible amount of sales and be able to make some serious money. So if you're the only person in the US that can make and sell that product there, then it can be incredibly valuable. And fortunes have been built on the back of strong IP rights. There are assets that can be bought, sold, and licensed. I understand that about 2/3 of the enterprise value of ASX 200 companies are intangible assets like IP. So their value shouldn't be overlooked in terms of what they can do for your balance sheet. Which if you're trying to get commercial partners or sell your business, can be really, really important. They're great for commercial arrangements and partners and collaborations. I've got some clients that have done some work with University of Tasmania, for example, and by having some IP in place, it's enabled them to get in and form a partnership and do some work that they wouldn't normally be able to do, and also maintain those rights at the end of it as well. So they've done really well out of having that IP in place and being able to get those partners to the table, control the technology, and develop it and take it somewhere that they couldn't take it themselves. There's plenty of intangible benefits as well: brand recognition and credibility, warding off competitors, product and brand development. There's a whole lot of psychological factors that come into intellectual property protection as well, which shouldn't be overlooked. So what do we need to know? We've got these great tools. How do we use them? And what catches are there? Well, unfortunately, the system is such that you actually need to know about IP, which is a hard thing because you don't know what you don't know, and people aren't going to come out and tell you what you don't know about IP because they're looking out for you. The system doesn't work that way. So you need to know about it first, which is difficult. And we spend a lot of time doing these sort of seminars every year because we're just trying to get out in front of people and tell them what they can and can't do. And with a bit of knowledge in hand, they can explore whether it suits their business, because it's quite an unfortunate situation that we often have at times where people come to us and say, I've been doing this, but geez, I wish I'd met you 2 years ago because now we're down a path that we don't wish to be on, and we didn't need to be this way. The systems are long and complicated, and there's lots of actions and deadlines, and the systems require you to have knowledge of them. You're not getting constantly reminded of upcoming deadlines. They just pass without your knowledge, so it's really a difficult place to play in for the uninformed, and many traps. So in terms of advantages of international protection, often the advantages are the same that you have here. You've got your monopoly rights and your ability to stop competitors using your intellectual property, which can be incredibly valuable, as I mentioned earlier. You've got the ability to get into collaborations and partnerships, but also distributors and suppliers. Your ability to engage and attract them becomes even more important. For example, if you're trying to get into a market like Europe, for example, from Australia, it can be quite a difficult thing to do. But if you can establish a partnership with a distributor over there who's already got great distribution channels and contacts, you can really take advantage and leverage their skills to do quite well out of that. But before they're going to sign an exclusive distribution agreement with you, they're going to want to know about your IP. Now, if you've got some rights in Europe, that's an easy conversation. But if you don't, then the sort of arrangement that you might have with that distributor becomes very different. And what you've got to worry about is that you start you get a loose agreement with them, and 6 months down the track they realise that they can get it made cheaper somewhere else, or made differently, or made better. You've got nothing left to tie them to you without that agreement. So intellectual property can be really important. If you've got strong trademark protection, you can exercise controls around your branding and how it's applied in terms of the manufacture and the distribution and sales as well. So that can be really quite useful. If you're a Tasmanian brand, for example, and you've got lots of brand values and principles, and your product is made in a certain way, and that's the way it needs to be. If you get into a situation where you want to start making it overseas, you really need to be in a situation where you can control the quality and how it looks and how it's used and how it's marketed, for example, because that can really do some bad damage if you're not on top of that. So having those strong rights in place gives you the opportunity to exercise those controls and protect the hard work that you've put in building your brand in Australia. So I'm going to run through now the issues, the common issues with international protection. I'm going to split it up into the different forms of protection, just because they're often quite unique to each other. And then finally, I'm going to spend some time talking about China, because that's a really quite an interesting one for IP rights owners. Now, when it comes to trademarks, availability of registration in overseas markets is not a given and should never be assumed as such. It's quite a common situation to have some rights in Australia, be operating here, have your trademark registration in place, and want to go overseas and find you've got trademark issues. It's really common. Even the likes of Breville, for example, has to sell in the UK under a different brand because they don't have the registrations over there. And that can really complicate things for a small business if you're having to sell under different brands in different jurisdictions. So it's worthwhile, and related to that problem is actually freedom to operate and infringement. You might be a company in Australia operating for 10 years and have no issues, and as soon as you try and move to Japan, for example, you find that somebody has a similar trademark already registered there, and you had absolutely no idea, but you've started selling there, you've got product on the ground, so you've all of a sudden got a problem. These sort of issues can be managed in advance by doing some clearance searching here, looking for other trademarks to make sure that, one, you can get your own registration, and two, checking to see what infringement or potential infringement issues exist, and that can be done in advance before you commit to packaging and start loading products on boats, for example. So certainly a situation where the prevention is much easier than the cure. The other issue overseas is trademark squatters. It's particularly an issue in China, and I'll talk about that a bit more in detail in a few minutes. The system in Australia is such that the first person to get trademark rights is the first person to start using them. In countries like China, the system's different, where the first person to get the rights is the first person to register. And that's not an uncommon system. There's actually more countries that are first to file than first to use. But there's some peculiarities with the Chinese law that allows people to, anyone off the street, to register any trademark that they like, and then it can be quite difficult to get it back. But it does exist in other markets as well. So it really pays, before you start expanding your international operations, to do some research on the trademark front, see what's free, see what's used, and it may be that you need to rebrand, but the sooner you know that, the better you are, and that can avoid all sorts of issues. When it comes to patents and design registrations, the issues are often quite similar. You can extend Australian rights within certain timeframes under certain international conventions. the way the system works is that you file for protection in Australia, and in foreign jurisdictions, they'll open the door and they'll leave it open for you for a certain amount of time. And if you extend your application into that country within that time frame, well, then fine, you've got your rights. If not, then the door closes and that technology goes into the public domain. The difficulty that a lot of clients have is that you can often, if your product development cycle takes too long, you can find yourself in a situation where you're having to make decisions about foreign protection without understanding your markets. And that's really quite relevant at the moment with COVID-19. I've got a number of clients that are in the process, and they know they've got international markets, but until they can actually get on a plane and go and talk to distributors and do that hard work, they're hesitant to commit to the funds of going overseas. So it's really quite a difficult situation to be in. You can also get different rules and regulations that have a strong impact on the type of rights that you'll get, the type and the scope. We've got clients with situations where the patent scope is different from Australia, US and Europe, and a certain product that's an infringement in Australia and the US is not an infringement in Europe. So it's there's no blanket international IP rights that are consistent across countries. So that can create quite a few complications, and it's something to be aware of. The other issue is freedom to operate. Now, this is an odd situation where you can have a patent yourself, but to use that patent, you actually have to infringe somebody else's patent. And you could just think about something like a famous example is the Dyson cyclonic vacuum cleaners. There's some patents around the core technology and then to a bunch of improvements. Now, if you need that core technology to use your improvement, then you're in a difficult position because you can't do that without their consent. So you do get these crazy situations where you've got your own patent, but you can't use it unless you've got a commercial arrangement with the other party. Now, in the scale of the world, number of rights in Australia are quite small compared to the US, for example. And you might not have an issue in Australia, but once you go into the US, where there's many more patent rights, you might find that the freedom to operate position in the US is different, and you don't have a patent infringement issue in Australia, but you do in the US. So it's again, it's something that can be mitigated through some searching here, as long as you know to do it, or you can think to do it, or ask the questions in advance. We can do that sort of searching and try and see what risks there are, particularly with countries like the US, where they're much more patent savvy. They are more litigious as well, and no one's surprised by that. But if you're going to get sued, you might get away with it in Australia, but unlikely to get away with it in the US. So it's certainly worth being aware of. Now, China, I've put this on a separate slide because there's a few peculiar things about China that they're very unique, and it is such an important jurisdiction now, and lots of they have a real thirst for clean green products, and I think Sally would probably agree that there's lots of Tasmanian businesses that really want to get products in China, or it's becoming a really important market for them. Now, as I mentioned earlier, trademark squatters in China can be a real issue. In the last couple of years, there's been some law changes there, which has really tried to reduce the impact, and they are working to some extent. But what we're still finding is that prevention is much cheaper than the cure. So, for example, 3 years ago, the top 10 trademark filers in China, 8 of them were Chinese firms, Chinese national companies that were trademark squatters. They would just file thousands of foreign trademarks that they were holding, and just waiting for owners to come in, and so that they could effectively ransom off the rights. Out of the top 10, only 2 companies were like a Microsoft or a Sun Microsystems or an Apple that were a legitimate large corporation. The rest were squatters. Last year, that's turned around. Now, out of the top 10, I think the top 8 are legitimate corporations, and there's still a couple of trademark squatters. So the problem is there. It's much less than it was, but it particularly becomes an issue if you're going to trade fairs and the like. There are people that will do their rounds and look for businesses that are there, that are new, that they've never seen before. And a Chinese national can file a trademark registration reasonably cheaply in Chinese, and you won't know about it until you try and sell your products there, and then you have an issue. It's a really common problem. Many people have been caught out, including many big names. I think Louis Vuitton, Tesla, Starbucks. There's a really long list. So there's no shame in being caught up in it. But given that there's been so many problems, there's not too many excuses these days not to look at it in advance, because it can be very expensive. Another issue with trademarks in China is Chinese language trademarks. Whether you like it or not, selling a product in China, you'll often end up with a local name, and a lot of companies have been on the front foot with this and have chosen their Chinese name, and they market under that name to build a reputation under that name, so that their name is consistent with their brand values and what they like, because often they can, there might be a literal translation, or it might have other meanings to it. So, it's very important to control that. If you're a company looking to move into China, you might want to think about it, whether or not you want to choose, or let the market choose for you. If you don't register that Chinese name trademark, then somebody else will. And there's lots of examples where companies have come unstuck because someone in China's filed the Chinese language name, and they're frustrating their efforts to sell products. You might have seen, over many years now, Penfolds has been fighting a battle with a company over there on the name Benfu, which is sort of the Chinese equivalent of Penfolds, which I think is something about riches or something like that. There's a bit of a story behind it, but so they've been fighting that battle, and it's cost them a hell of a lot of money. And had they registered their Chinese mark at the outset, it would have cost them a couple $1,000s to do so, and and now they're spending hundreds of thousands of dollars of this litigation trying to get something back. And the infringing company's been using it for so long now that they have a bit of a reputation in their own rights, and so it's a very messy argument that is largely avoidable. Another issue in China is patent and design registration incentives. Now, there are government incentives in place and the purpose of them is quite noble. It's to encourage and incentivize intellectual property generation. I mean, obviously it's a developing country, and they want their citizens to invent and create their own intellectual property. But that system has been widely misused, and people are filing for protection for products that aren't theirs. It's a reasonably common occurrence for a foreign product owner to want to get their product made in China. The owner realizes that there's no IP on it, so they file their own patent or design application There's so many of these going through the government, they're not checked, that it's never picked up, but they get their rights, they submit the certificate to the government, get their money back, and are quite happy with themselves. You might think that really doesn't create much of a problem for you being in Australia, because what does it matter how they do things in China? But it often comes to light when they jack up their price 10%, over a couple of years, and when you decide that you've had enough and you'd like to shop around, you find that you can't, because they hold patent or design or trademark rights over your product that you didn't realise. Obviously, they're invalid, and there's mechanisms to get them back, but it's going to take you 12, 18 months, possibly longer, possibly shorter, and many thousands of dollars to go through the judicial process to do that. Whereas if you had those rights in place to start with, it wouldn't be an issue. So getting things done up front is a much better position to be in than down the track. Another odd thing with China, or unique, I should say, customs seizures. And customs seizures they happen all around the world. In Australia, we do it on the way in. If you're a brand owner, you register your mark with customs. When products come in bearing that mark, if they look a bit odd, customs might put them to one side. They'll go to the register, they'll call you up, you'll go down, you'll look, you'll eyeball the goods and say, these are legit, these are what I ordered, or I've got no idea where these came from or who made them, these are counterfeits, they need to be seized. It's a great system, and a lot of brand owners use this to their advantage quite well. In China, they do this on the way out as well as the way in. And the issue with that is that if you're a brand owner, for example, you might be selling products from Tasmania into China. You might not have your brand protected in China, but somebody else does. They can be on the customs register at the ports. And so when your products, you make and you ship a container load of products to China, when it gets to port, it gets pulled over, notification goes to the Chinese national who's the brand owner. They rub their hands together, and then they next contact you and say, we've got this shipment here, it's under our control, we're the brand owner, you can have your products for might be 20, 40, 50,000, whatever it is. It's they know what your products are worth, and you've really got no choice but to pay the money to get the products through. Going through the judicial processes to get the trademarks back might take you 6-12 months, many thousands of dollars, and most people can't wait that long. So they ultimately have to pay, or the goods are destroyed. So from a brand owner perspective, it's a real risk. If you're making products in China, also it's a real risk, because they get checked on the way out. If so, you manufacture under license through a Chinese company. That Chinese company holds some IP rights, or a third party holds some IP rights, and they're registered at customs. You've made a shipment of products. It gets to the port. You've paid everyone along the way, and it gets seized. And all of a sudden, the brand owner puts up his hand and says, "No, you can't have these products until I get paid as well." And it's effectively a shakedown, and many people have been caught by this. And there's really little that you can do apart from just paying and trying to get the goods released. So again, being the registered rights owner in China is incredibly important. Finally, counterfeits. Now, counterfeits are a massive problem in China, and everybody knows that. Unfortunately, there doesn't appear to be a lot of interest at a government level of doing something about that, and that's not going to change anytime soon, we wouldn't expect. There's various programs now to deal with counterfeits. E-commerce platforms like eBay have Vero, verified rights owners system. Amazon have their systems, and I understand Alibaba as well. So, for example, if you have a patent in Australia or the US and you're getting some counterfeits coming in through Amazon, you can go to Amazon and pay the fees and go through the process to have your IP dispute heard at the Amazon level, as opposed to going to the courts. They can be quite fast and effective, and effective ways to enforce your rights. It's important to note that if you need to take this action, the quicker you do it, the better. The more infringements and counterfeits that you let out there, the harder it is to stop. So it's unfortunately, it is an onerous task for a brand owner, but it's something that people need to do diligently and constantly. And that those systems are out there as well. I've heard some reports about some other systems being used, particularly in the US, around seizing counterfeits and by way of chasing after the money and going after their PayPal accounts, because even though the manufacturer might be from China and the shipping from China, the money's in the US, and at some point the money has to pass through the US, and you can attack them that way. So there's always procedures in place to try and deal with these counterfeits, and it's important that people try and get on top of them early and just manage them as best they can, even though they are incredibly frustrating. Now, Sally, I might leave it there. I've covered a lot of ground, and unfortunately, with Zoom, I can't see and I can't get any feedback, so I don't know whether there were any things that people might have really been quite interested in and want to talk about more. So I'll pause here and we can maybe have some discussion.
Right. So attendees, please type your questions in the chat box. Michael, can you tell us a little bit about the Madrid Protocol, which can be sometimes the first step to IP protection?
Sure. Look, the Madrid Protocol is a great way to get your trademarks registered overseas. The path that most people use to get into Madrid is file their application in Australia. So you're a brand owner in Tasmania. You're doing what you're doing. You file for registration in Australia first for your Australian trademark. And there's a great program called the Head Start program, which means you can get your application examined really quite quickly. So you've got an idea as to your rights before you commit too much funds. And within 6 months, you can file an application under the Madrid Protocol. And the way that works is that you designate the applications made through WIPO, the World Intellectual Property Organization, and you can designate what countries of interest you have that you want trademark protection in. So that might be maybe Europe's done as a region, except for the UK from the end of the year. Might be New Zealand, China, Japan, US, whatever weird and wonderful places you have markets in. And procedurally, that's administered at a central location, which is quite useful. And it's not unless there are significant issues with your application that you need to get local representation and get help. So it's really quite a cost-effective, streamlined way of getting those rights through. And then once they're through, you can administer them quite easily as well. You pay your renewal fees in one place. You can handle transfer of ownerships at one place, for example. You don't need to have, if you want protection in half a dozen jurisdictions, you don't need to have half a dozen different applications that you need to deal with on an administration basis.
Thank you, Michael. You mentioned the UK during that answer. With Brexit, are there any implications for current EU registrants that covers the UK?
Yeah. So Brexit quite a complication, and it's quite interesting. So, for example, if you're a patent holder, the convention that the European patent comes under isn't affected by Brexit. So, if you've got a European patent application, Brexit makes no impact on that. UK is still part of the European patent convention. It's not contingent on European membership. But trademarks and designs are different, and so come 31 December this year, the UK is not going to be part of the convention for trademarks or design registrations. The way it's being handled is if your application is registered before that date, which means it's been submitted, it's gone through examination, and it's got the stamp, it's registered, they will basically split the registers. So your European right will just become an automatic UK right at the same time. So no great cost there. The only complication will be when renewal fees come up. You'll then have to pay 2 renewal fees instead of 1. So if you're an existing trademark owner, it's not a big deal. Brexit, it's more an administrative procedural concern that you've got to keep track of those different renewal fees and pay them. If you've got a recent application and it's not yet registered, then I understand that you need to refile in the UK, and so that becomes a UK application as well. And if you're looking at getting protection at the moment, the basic recommendation coming out of firms in Europe and the UK is to file a separate UK and European application at the same time, just in case.
Thank you, Michael. You mentioned renewal fees, and in a session previously here in Hobart, you told us about bogus renewal fee advices.
Oh, yes.
Cover that for us, because I found that totally interesting.
Yeah. So trademarks need to be renewed every 10 years at various for patent applications in various jurisdictions. Annual renewal fees start at different points, and so it gets a bit confusing and a bit hard to track. And you, if you haven't been through the system before, you sort of get bombarded of different reminders at different times. And there's companies out there that they mine the data from the patent systems and they of applicants, and they send out these fake renewal notices, and people get these renewal. Often it might be like a publication notice that says publication in this journal or a renewal or something like that. And the giveaway is that it's often they're asking you to pay into a bank account in the Czech Republic or somewhere that's quite unusual. And they just, they send out these notices by the thousand, and a small proportion of people actually pay them, so they're still making money off it. But they do, and if you're not careful, you can pay these fraudulent invoices, and you'll never see that money again.
Right. And talking money, what is the cost of IP registration for various things? Are you able to give us some examples, please?
Yeah. So for a basic trademark application in a single class, it's a little bit over $1,000. And if there aren't too many issues that come up during examination, you can go start to finish. You can get your Australian trademark for somewhere between $1,500 and $2,000. So it's not a massive expense. And one of the great things with doing an Australian trademark is that when you file the application, it gets examined, and potential infringement issues in Australia, at least, get brought up at that stage. They can often be fleshed out, because you might be a Tasmanian company making and selling something in Tassie, and completely unbeknown to you, there's a company in working out of Brisbane that's using the same trademark in the same space. They've got the registration, and until you get big enough to get on their radar, you don't know. But when you do get big enough, you've got a problem. And going through the process of registering your own trademark can be incredibly valuable, and just fleshing out those issues at an early stage, and rebranding early on when you're still not committed to websites and packaging and the like is a much easier thing to do. So a simple trademark can be quite cost effective in Australia. If you wanted to extend that mark into China, for example, it gets more expensive because you end up paying local agents as well need to be involved in that process, and we start getting translations and the like. But all up, you might be looking sort of $3,000 to $4,000 over that process to get that through. The filing, you're looking around $2,000. Just depending on how many issues that come up. So, a reasonably straightforward one might be through in under $3,000, for example. So, you've got your protection in Australia and China for potentially sort of $4,500. So it's not cheap, but when it comes to avoiding legal disputes, and if you get into a trademark dispute with someone and you end up with lawyers involved, you'll $5,000 or $10,000 will just disappear before you know it. Just a few different letters and certain allegations. So it is a form of insurance.
Thank you. And if you were to give, say, 3 top tips to our attendees today, Michael, what would they be?
Yeah, think about your branding early and get your trademark application in. It's such a common issue for a startup to choose a name and not not think too much about it, or not spend enough time researching it and finding out the issues. They get some traction in the marketplace, they get some investors on board, and before they know it, they've got a trademark issue and they have to rebrand. If they're selling products in the market and there's allegations of infringement, and you might have, I've got a client at the moment who's working on a supply deal with Harrods in London, and they haven't done their trademark due diligence at the outset, and so at some point they're likely to get sued, and how much damage that does to the relationship with Harrods, we're just not going to know until it happens. So they've done all this hard work, and it's going to be undone to some extent just because the due diligence wasn't great at the outset. So filing your own trademark early on is really important. If you're going overseas, particularly China, the next bit of advice would be to, before you go to that trade fair, get your, if you've filed in Australia, you've got 6 months before you have to file in China. If you file within 6 months, you can claim your Australian date as your filing date, which is useful. So if you are going to go to a trade fair, then at the very least, get your Australian application in first. And if you've got your Australian registration sorted, then get something on file in China before you start publicising there, because it will bite you. I mean, there are people out there that's their business model to file those applications and frustrate your efforts. So for the cost of getting it back down the track, just get something in place first. And the third bit of advice, I think, around products, a lot of people don't realise that the patent system is there, and I didn't even mention it today because we didn't really go into detail of patent rights, but there's this great thing called the innovation patent, and it is on its way out. It's towards the end of next year. It's going to be phased out through IP Australia, but it's a really valuable tool that allows people to protect low-level innovations, and it's great for products that might not, you think might not be that new and inventive, but they can often be protected by way of an innovation patent and enforced quite well. It's great for things like packaging, for example. If you've got an interesting product and you've had to do some work on some packaging to get it to market, an innovation patent can be a great way to protect that. It's great for things that have a short shelf life. It's only 8 years protection, but it's can be cost effective. It's procedurally not difficult to get. So a lot of people don't think about that, but it's really quite valuable.
Excellent. Thanks very much, Michael. We're almost out of time, so I just want to take this opportunity to thank you, Michael, for your time today and invaluable information. Also, this webinar was free, and it's really great that you've been able to be with us and to be so generous with your time. Michael's contact details are on the screen. You can see his email address and also the Cooper IP web address. So please feel free to reach out to Michael, and he can assist you in the first instance. If you would like to contact me at any time, please do so at the TCCI. And if you would like to contact my colleague, B. Clifton, at TradeStart at the Department of State Broking Launceston, then please reach out to me. Any one of us can help you with your international trade requirements. Again, Michael, thank you very much. We really do appreciate it. And that's the end of our Zoom meeting today. Thank you all.
Great, thanks for attending. Thanks, Sally.